Oh God, I'm live. Hey. Okay. It's like it's video. It's videoing this time. So we're reading about class actions. A class action is a case in which representatives sue on behalf of a group. Initial requirements to qualify for a class action. All four of the following requirements must be demonstrated. Numerosity means that there are too many class members for practicable joinder. There is no magic number. Commonality, there must be some issue in common to all class members, so resolution of that issue will generate answers for everybody in one stroke. Typicality, the class reps' claims are typical of the claims of the class. Representative adequate, the class rep will fairly and adequately represent the class. So those are the four initial requirements. The type of class action is the next hurdle, in which after satisfying the first four prerequisites, the action must still fall into one of three types of class actions, which type 1 is prejudice. For type 1 class actions, class treatment is necessary to avoid harm, prejudice, either to class members or to the non-class party. These types of class actions are rare. Type 2, injunctive or declaratory relief. In type 2, class action seeks an injunction or a declaratory judgment because the defendant treated the class members alike. Plaintiffs in type 2 class action generally cannot seek damages. And type 3, common question or damages. For a type 3 class action, 1, common questions must predominate over individual questions, and 2, the class action is a superior method to handle the dispute. This type of class action is frequently used for mass torts. And I think that prejudicial one probably is trying to refer to limited fund, and like BARBRI is like making up their own names for things. Limited fund of money. If the plaintiffs were to sue individually, the fund would be depleted before the claimants get to court. So I probably wouldn't refer to that as prejudice. I'd probably refer to that as limited fund. And there's a table, a chart on page 63 showing numerosity, commonality, typicality, fair and adequate representation on your left, and on your right, the three different types, including limited fund, injunctive and declaratory relief, and common questions predominate, and a class action is superior to alternate methods of adjudication. So predominate. A federal class action must meet all four requirements on the left side of the chart and one of the requirements on the right. So it has to fit into one of the types, but it must have all of the four prerequisites. Only the third type, the common question type, requires notice to all class members and allows opting out. Court must certify the class. The representative's complaint will say class action, but the case is not a class action until the court grants the motion to certify it as a class action. The court must also define the class and the class claims, issues, or defenses, and appoint class counsel who must fairly and adequately represent the interests of the class. However, the court rules on the certification motion. The court rules on the certification motion, the losing party can seek review from the Court of Appeals, period. It's discretionary with the Court of Appeals. Notice to class. In a type 3 class action, the court must notify class members that they are in a class. This means individual notice, usually by mail, to all reasonably identifiable members. The notice, paid for by the rep, tells the class members various things, including that they can opt out, will be bound by the judgment if they don't opt out, and can enter a separate appearance through counsel. This notice is not required in type 1 or type 2 class actions. Opt-out and binding effect of class action judgment. There is no right to opt out of a type 1 or type 2 class action. All class members are bound by the judgment unless in a type 3 class action they opt out. Settlement of class action. The parties can settle or dismiss a certified class action only with court approval. And in any of the three types, the court must give notice to the class members to get their feedback on whether the case should be settled or dismissed. If it's a Type 3 class, the court also might refuse to approve this element unless members are given a second chance to opt out. SMJ in class actions. If the class action asserts rights under federal law, federal question jurisdiction may be used. For diversity cases, only the citizenship of the class rep is considered, and her claim must exceed $75,000. Claims of other class members are ignored. That means that as long as the class rep's claims meet the requirements of diversity, the class action may use diversity. And then there's the CAFA, the Class Action Fairness Act, granting subject matter jurisdiction separate from diversity of citizenship jurisdiction. It lets a federal court hear a class action if there are at least 100 members. Any class member, not just the representative, has diversity of citizenship. And the aggregated claims exceed $5 million in total. So this is CAFA. Comparatively, use it to meet numerosity, no specific number. And the rep diversity was a requirement. And the rep had to have a greater than $75,000 claim. So I'm going to call that 23B probably, though it doesn't name it. Local actions will stay local, it says. Okay, so before that, also anyone defendant, even an in-state defendant, may remove the case from state to federal court. All this makes it easier for interstate class actions to go to federal court. Local actions will stay local. There are complicated provisions to ensure that local classes where most class members and the primary defendants are citizens of the same state do not stay in federal court. These cases get dismissed, or if they are removed from state court, remanded to state court. So there's just a local interest in local class actions, and it probably uses some type of a percentage of the class residency. It's probably how that's determined, but they're not even going into it in BARBRI because they don't think it's important. So Module 10 is about discovery. The basic idea is that discovery is the phase of litigation in which the parties find out what the other parties and witnesses know. The idea is to avoid trial by ambush. We want things known before we go to trial. Initial required disclosures are information that each party must give to the other parties, even though the parties have not asked for it. Unless a court order or stipulation of parties says otherwise within 14 days of the 26F conference, each party must disclose certain information. So initial disclosures are 14 days from 26F conference. Identities of persons with discoverable information that a party may use to support her claims or defenses. Telephone numbers, addresses of those persons with discoverable information, and the topics to which they have discoverable information, who the party may use to support their claims or defenses, must be disclosed in the initial disclosure. May be used. Documents and things that a party may use to support her claims or defenses. Documents and tangible things that the party may use to support their claims or defenses may be disclosed as an initial disclosure. This includes photographs, records, videos, and ESI. So photos taken on a smartphone are included, as well as good old-fashioned papers, copies or a description of the documents may be produced instead of the document itself. It must be in parties' custody or control. Documents and tangible things that are not in the parties' control need not be disclosed. Computation of relief and along with supporting documents, ESI. Anyone claiming monetary relief must provide a computation supported by documents or ESI and the amount sought as an initial disclosure. So I'm writing computation of relief sought and support. That's just putting it in my own words. Insurance coverage. The parties must disclose insurance that might cover all or part of the judgment in the case, even though the existence of the insurance probably would not be admissible at trial. Discoverable is broader than admissible. Penalty for failure to disclose. If a party fails to disclose material that was required to be disclosed, that party cannot use the undisclosed material in the case unless the failure to disclose was substantially justified or harmless. Required disclosures about an expert witness. Later in the case, at a time directed by the court, each party must identify expert witnesses who may provide testimony at trial, that is, opinion testimony, and provide certain other disclosures noted below. Distinguished consulting experts. Suppose a party hired an expert to help with preparing a case, but she doesn't intend to call the expert to testify at trial. Such an expert is not an expert witness, but rather a consulting expert. Facts known and opinions held by the consulting experts are generally not discoverable absent exceptional circumstances. Contents of disclosures, identity, and report as to an EW who may be used at trial. Each party generally must disclose to the other party an identity of and written report prepared by the expert witness. The written report must include So I'm just writing consulting expert and exceptional circumstances would need to be required. Whereas the witnessing expert, there's all these things to include, just like their identity, their report, opinions to be expressed, basis for the opinions, facts to form opinions, qualifications, and pay. So earlier drafts of the EW report and communications between the lawyer and the EW are work product. So I'll just write here final in parentheses, not WIP. Deposition of expert witness. After the disclosure above, a party may take the deposition of the expert witness. Best practices for that party to subpoena the expert witness to compel her to her attendance. Without the subpoena, the expert may not show up, even if the parties agreed to the deposition. The deposing party ordinarily will bear the cost of the expert witness's deposition. The court will set a per-hour fee. Failure to disclose. If a party fails to disclose material that was required to be disclosed, she cannot use the expert witness in the case unless the failure was justified or harmless. Required pretrial disclosures. No later than 30 days before trial, the parties must give detailed information about the trial evidence, including identity of witnesses, who will testify, live or by deposition, and documents, ESI, or other things they intend to introduce at trial. 30-day pretrial disclosure of evidence, basically. And discovery tools. Once the initial disclosures have been made, parties may request information from one another. However, assuming that no court order or stipulation provides otherwise, a party cannot send discovery requests to another party until after the Rule 26F conference. Minor exception requests to produce can be served earlier once 21 days has passed since service of process. Such a request is treated as though it was served at the Rule 26F conference. Generally, the cost of responding to discovery is borne by the responding party. Depositions. So a request for discovery can be 21 days after answer. At the earliest, but more like 21 days after the 26F conference, I think is what I'm reading. Such request is treated as though it was served at the 26F conference. So, depositions. In a deposition, a person gives live testimony in response to questions by counsel or pro se parties. The questions are usually oral but can be written. If written, they are read by the court reporter. The deponent testifies under oath, and the deposition is recorded by sound or video or stenographically so that a transcript can be made. Both parties and non-parties may be deposed. The deponent isn't required to view her records prior to the deposition. Testimony is from present recollection. Notice to parties, subpoenas to non-parties. A party does not need to be served with a subpoena. A notice of deposition is sufficient to compel her appearance. A non-party must be served with a subpoena, or else she is compelled to attend. If the party noticing the deposition fails to do so and the deponent fails to show up, the noticing party may be liable for costs to the other parties. Discovery. Okay, I went backwards. Forwards on page 70, subpoena ducis tecum. A subpoena ducis tecum requires the deponent to bring requested materials with her to the deposition. Limit on deposition of non-party. Unless the non-party agrees otherwise, the farthest she can be required to travel is 100 miles from where the non-party resides or is employed. Deposition of organization. When the party is suing an organization, she may notice a deposition of an organization describing the facts that she wants to discover. In the deposition, the organization then must designate a person to testify on the matter. Limits on depositions. A party cannot take more than 10 depositions or depose the same person twice without court approval or stipulation. Depositions cannot exceed 1 day of 7 hours unless the court orders the parties stipulate otherwise. Use of depositions. Subject to rules of evidence, depositions may be used at trial to impeach a deponent for any purpose if the deponent is an adverse party, or for any purpose if the deponent, regardless of whether a party is unavailable for trial, for example, illness, out of the country, etc., unless the absence was procured by the party seeking to introduce the evidence. Interrogatories. So you're really supposed to keep depos down to like 10. One day, 7 hours, right? Those are the potential uses. And now we're talking about interrogatories. They're written questions to be answered in writing under oath. They are only sent to parties, never to non-parties. The maximum number, absent a court order or stipulation, is 25. Answer them within 30 days of the service. A party must answer interrogatories based on information reasonably available. If the answers to interrogatories can be found in business records, then the burden of finding the answer would be about the same for either party. The responding party can allow the requesting party to have access to the records. Contention interrogatories, that is, interrogatories that inquire about legal contentions, are permitted. And request to produce. A request to produce asks a party to make available for review and copying documents or things, including electronically stored information, or to permit entry on designated property to inspect, measure, etc. ESI must be produced in a form that the requesting party specifies, but the responding party may object. The disclosing party must respond to the request in writing within 30 days of service, stating that the material will be produced or asserting objections. Only parties can be sent a request to produce, but a non-party can be served with a subpoena to require her to disclose the same types of information. So the response was in 30 days, I think I read. Now, medical exam, physical or mental, requesting copy of the report, request for admission, signature requirement for discovery, duty to supplement. And that's going to finish out that section, and we'll go into scope of discovery. So I kind of feel like just reading the bold here. For the medical exam, the court order is required to compel a party or person in the party's custody and control to submit to a medical exam, and the requesting party must show that the party's health is an actual controversy and good cause. Custody and control is narrow. For example, an employee is not in custody or legal control of the employer, but a child is in the custody and legal control of her parent. The requesting party chooses the licensed medical professional to perform the exam. Requesting a copy of the report. Once the court orders a medical exam and the medical professional conducts the exam, the medical professional will write a report and give it to the requesting party. The person undergoing the exam can get a copy of the report. If the person requests and obtains the report, she must, on request, produce all medical reports by her own doctors about that same medical condition. She also waives any doctor-patient privilege that she may have had with her doctor regarding that condition. So it sometimes might be more wise not to ask for the opposing party's medical professional's report in order to preserve those details that the plaintiff has privileged among their own medical team. And request for admission, just reading it to see. Okay. I was just curious how it gets in this section. So a request for admission is a written request that someone admit certain matters. Not necessarily relating to medical exams, just any document or other matter like a photograph or really anything that's being admitted to evidence. So the responding party must submit in writing within 30 days of service, either denying or specifically or objecting. But if the responding party states that she has made a reasonable inquiry and cannot find enough information from which to admit or deny, she can state that she doesn't know the answer. If the party fails to deny a proper request, the matter is deemed admitted. Requests for admission are often used to authenticate documents. Admit that this is the contract, for example. So I'm guessing this is usually between the parties. So I don't know if they're talking about a stipulation or if this is just a kind of stipulation, but it seems strange that it just gets smushed in this section. Signature requirement for discovery. Parties sign substantive answers to discovery under oath. Rule 11 does not require or does not apply to discovery documents. However, by another rule, every discovery request and response is signed by counsel certifying it is warranted, not interposed for an improper purpose, and not unduly burdensome. Duty to supplement: if new facts come to light after responding to discovery that make a required disclosure, interrogatory, request for production, or request for admission incomplete or incorrect, the party must supplement her response to discovery. This is a self-policing obligation. And so it's kind of an expectation in federal court, but apparently in the state of California, you have to inform the other party that this is an expectation. Scope of discovery now. Section 10.6.1, the standard is that a party can discover anything that is relevant to a claim or defense and proportional to the needs of the case. So relevant, claim or defense, and proportional to needs. That's discovery scope. Unlike initial disclosure, something harmful to you may be discoverable using the regular discovery tools, and note that discoverable is broader than admissible. Information need not be admissible to be discoverable. Privilege: a party can object to discovery on the basis of evidentiary privilege. For example, confidential communications between attorney and client, work product protection, work product or trial preparation material, which is material prepared in anticipation of litigation, is protected in federal court. Work product need not be generated by a lawyer. It can be prepared by the party herself or by any representative of a party. For example, a private investigator. Qualified versus absolute work product. Work product sometimes may be discovered if the requesting party can show substantial need and undue hardship in obtaining materials in another way. This is called qualified work product. Some work product, however, is absolutely protected, cannot be discovered. Opinion work product consists of mental impressions, conclusions, opinions, or legal theories of the disclosing party and cannot be discovered. So, opinion work product, mental impressions, conclusions, opinions, theories. Are absolutely privileged. Now, moving on, party's own statement is discoverable. Notwithstanding work product, a party has a right to demand discovery of any previous statement that she has made regarding the case. Asserting privilege or work product. If a party withholds discovery or seeks a protective order based on privilege or work product, she must claim the protection expressly and describe the materials in detail. She does this in a document called Privilege Log that lists the materials protected by date, author, and recipient, and privilege or protection claimed. It must be enough detail to allow the judge to determine whether the material is protected. What is this document called? An inadvertent disclosure of privilege or protected material. If a party inadvertently produces privileged or protected material, she should notify the other party promptly. The other party must then return, sequester, or destroy the material pending a decision by the court about whether there has been a waiver. Enforcement of discovery rules. Interesting thing about that whole section is it doesn't tell you when anything has to be done. So I guess it's all just like within a reasonable time. but like I would garner to say that you have to return it within a certain amount of times or have motion to the court a declaration whether there's been a waiver of a privilege within a certain time, but I don't see any time frames listed in that paragraph. That might not mean that they don't exist. It just means that BARBRI didn't think we need to know them. Enforcement of discovery rules. There are 3 ways courts get involved in discovery disputes. The party seeks a protective order, the party responds but not fully, and no response to discovery request. And then how to sanction the party is the next section. So let's just read about the protective order. Everything else is pretty short and self-explanatory. If a responding party thinks the discovery request subjects her to annoyance, embarrassment, undue burden, or expense, and the expense might be that ESI is not reasonably accessible without undue expense, or the request is cumulative, not proportional, she can move for a protective order. The party must certify that she tried in good faith to resolve the issue without court involvement and that she asked the other side to meet and confer. One other thing that's not written here that they might say is their privacy rights. They might object on account that it's just like proprietary information. That's another reason that parties seek protective orders. Actions the court can take: if the court agrees, it can deny discovery, limit discovery, or permit discovery on specified terms, that is. If a party doesn't fully respond, she may be compelled to comply by court order. If there's no response, like to attend deposition, respond to interrogatories, or request for production, she'll be subject to various sanctions plus costs. Sanctions against the party. Party seeking sanctions generally must certify that she tried in good faith to get the information without court involvement, that is, try to meet and confer. So, meet and confer, and protective orders, right? And there's a couple. Annoyance, embarrass, undue burden, not proportional, private, proprietary. So meet and confer plus good faith. Which would be a full, timely response, I should say. So then you've got sanctions, and those follow a 2-step process. The requesting party moves for an order compelling the producing party to answer for unanswered questions, to produce the unproduced material plus costs, including attorney fees, to bring motion. And if the producing party violates the order compelling her to answer, the court enter merit sanctions, see below, along with costs and attorney's fees for bringing the motion are available. The producing party could be held in contempt for violating a court order, except there is no contempt for refusal to submit to a medical exam, no response. If the producing party fails to respond at all, the court can enter merit sanctions plus costs and attorney's fees for the motion. There is no need to get an order compelling answers. You go directly to merit sanctions. Merit sanctions, a judge is free to choose among the following as merit sanctions: establishment order, establishes facts as true; strike pleadings of the disobedient party as to issues regarding the discovery; disallow evidence from the disobedient party as to issues regarding the discovery; dismiss the plaintiff's case if bad faith is shown; or enter default judgment against defendant if bad faith is shown. Litigation hold. When litigation is reasonably anticipated, parties must preserve, litigation hold. This reminds me of something else I didn't write down, which was, what was it? Inadvertent disclosure of privileged information. Inadvertent disclosure of privileged info. So back to this litigation hold. I mean, ESI or some has some special rules. Suppose ESI is truly lost, it cannot be recovered or restored. This is different from Hypo 10G, in which the ESI could be restored. And suppose it was lost because each the party in control of it failed to take reasonable steps to preserve it. The court may order measures to cure the harm caused to the other party. Can the court enter an adverse inference order? That is, tell the jury that it must presume the lost information would be unfavorable to the party that lost the ESI. Can it enter merit sanctions? Only if the party who lost the ESI acted with intent to deprive the other party of the ESI. The court also may enter a default against the defendant when her conduct was in bad faith. So I'm going to move on to Module 11, which is adjudication without trial. Just reminding me, how many modules do we have? There was 1 through 8, and then there was, okay, there's going to be a total of 14. So we're now in Module 11, adjudication without trial. We know obviously one of them is going to be claim preclusion and collateral estoppel. So adjudication without trial, we're going to have a trial section 2, so that's going to be 12. That one's going to be 14, and then 13. It's probably going to be about J-moles and sort of so. Basic idea. There are various ways a case can be resolved without going to trial. In addition, we need to know about provisional or preliminary temporary injunctive relief. Preliminary injunctive relief. Let's say a plaintiff is planning to file a suit or is sued. The plaintiff is worried that before the case can be tried, the defendant may do or fail to do something that will prejudice the plaintiff's case. So the plaintiff wants injunctive relief. That is a court order that the defendant either do something or refrain from doing something. Courts are nervous about granting injunctions because the merits of the underlying dispute have not been decided. Differences between a temporary restraining order and a preliminary injunction. An order that maintains status quo until trial is a preliminary injunction. Before getting a preliminary injunction and to maintain the status quo until the hearing on the preliminary injunction, you may seek a TRO, temporary restraining order, which is issued to preserve the status quo until the hearing for a preliminary injunction can be held. A TRO may be issued ex parte, which means the court has done something without giving notice to the other party. The court will issue a TRO ex parte only if the applicant files a paper under oath clearly showing that if the TRO is not issued, she will suffer immediate and irreparable harm. She must wait until the other side is heard. The applicant's lawyer certifies in writing her efforts to give oral or written notice to the defendant or to the defendant's lawyer, or why such notice should not be required in the case. If the court issues a TRO, the applicant must post a bond to cover the other side's costs and damages caused if it turns out the restraint is wrongful. If the court issues a TRO, the order must be served on the defendant as soon as possible. Generally speaking, a party without notice of a TRO cannot be punished for violating it. A rule granting or denying a TRO ordinarily may not immediately be appealed. Contents of TRO. A TRO must state its terms specifically, describe in detail what the defendant must do or refrain from doing, state why it was issued, and state why the threatened injury to the plaintiff was irreparable. Duration of TRO. A TRO is effective for no more than 14 days or lesser time stated by the court, but the restrained party may move to dissolve or modify it earlier. If the applicant shows good cause before expiration, it can be extended for up to another 14 days. So a TRO cannot extend beyond 28 days. If the court extends a TRO beyond 28 days, it may be treated as a preliminary injunction. So all of this I know is under Federal Rule of Civil Procedure like 64, I think. But they last 28 days max. Okay. preliminary injunction, section 11.4. A preliminary injunction maintains the status quo until the court can adjudicate the underlying claim on the merits. A preliminary injunction cannot be issued ex parte. The burden is on the plaintiff to show she is likely to suffer irreparable harm if the injunction is not issued. She is likely to win on the merits of the underlying case. The balance of hardship favors her, and threatened harm to applicant outweighs the harm to the other party if the injunction is issued and the injunction is in the public interest. There is no right to an injunction. The matter is in the court's discretion. So that's your TRO and your preliminary injunction. So they both quote, preserve the status quo. They both do that. But they require different things. And they also require the same things. So I can see there's at least 4 things here that the preliminary injunction requires. I'm going to look again, see if I can't dig out what the TRO requires. Yeah, it needed a paper under oath. So it requires an oath. Speaking to immediate harm, irreparable harm. The immediate and irreparable harm needs to be shown in both the TRO and the preliminary injunction. Notice isn't always required. On the TRO, it's always required on the preliminary injunction. Now, when it's not required, or can be, the TRO can be issued at ex parte. You really need to kind of give an affidavit, I want to say, of the explanation why this is ex parte. I really feel like there could potentially be some more things that have to be argued in the TRO, but that's probably in the preliminary injunction section. So the likelihood of winning on the merits, that's probably relevant to both. And then 5th is the balance of hardships. That's definitely part of both. So I'm bringing that over to the other side of my chart. And lastly, you can talk about the public interest. All right. Additional requirements for preliminary injunction. As with the TRO, if the court grants a preliminary injunction, the applicant must post a bond. Okay, so this one requires a bond, whereas the TRO, they could accept security. Also, as with the TRO, the preliminary injunction must state its terms in specificity, describe in detail why the defendant must do or refrain from doing something, and state why it was issued. In granting or denying the preliminary injunction, the court must make specific findings and of fact and specific conclusions of law. May be appealed. In order granting or denying a preliminary injunction may be appealed as a right, voluntary dismissal, dismissal without court permission. So this is a whole new section. If the plaintiff wants to withdraw the case, she may do so without a court order before the defendant serves an answer or motions for summary judgment. The parties may also stipulate to a voluntary dismissal without court order. For example, if the case is settled, a stipulated dismissal will be filed. Dismissal with court permission thereafter. the court permission is required absent a stipulation. If the plaintiff wants to withdraw in the case, she can make a motion for voluntary dismissal, which the court has discretion to grant. One dismissal without prejudice. The first voluntary dismissal is without prejudice. This means the plaintiff can refile the case, but you only get to do it without prejudice once. The second voluntary dismissal is with prejudice, which operates as an adjudication on the merits and takes away the plaintiff's ability to refile a case. Default and default judgment. A default and default judgment might occur when the defendant does not respond to the complaint in time, 21 days after being served with process and entry of default. A default is a notation by the court clerk on the docket sheet in the case. A default does not happen automatically. Rather, the plaintiff must move. Move for entry of default. The plaintiff must demonstrate that the defendant failed to respond in time. Until the default is actually entered, the defendant can respond by motion or answer even beyond 21 days. Effective entry of default. The entry of default cuts off the defendant's right to respond. Entry of default, however, does not automatically entitle the plaintiff to relief. The plaintiff must seek a default judgment. How to get a default judgment? The clerk of court can enter a default judgment if the defendant has made no response at all, that is, has not appeared. The claim itself is for a sum certain in money. The plaintiff owes an affidavit, sworn statement of the sum owed, and the defendant is not a minor or incompetent. I could probably write down some of this. So I really don't have it written anywhere else. And in the interest of time, can I have it memorized? Maybe not completely memorized, but I'm not getting these answers wrong in the NBE. All right, so there's doing it by the clerk if the defendant hasn't responded. However, if any of these is not true, the plaintiff must apply to the court for a default judgment. Hearing for a default judgment. The judge will hold a hearing and has discretion whether to enter the judgment. The defendant is entitled to notice of the hearing if she has appeared in some fashion in the case. Unlike a trial at the plaintiff's discovery, in a hearing for a default judgment is limited to what is pleaded in the complaint. Motions to set aside default or default judgment. The defendant may move to have the court set aside a default or default judgment by showing 1, good cause, like excusable neglect, and 2, a viable defense. Very generally speaking, a trial on the merits of the case is preferred. Motion to dismiss for failure to state a claim, FRCP 12B6. A motion to dismiss for failure to state a claim tests whether the case belongs in the litigation stream at all. If the plaintiff's complaint fails to state a claim, the case may be dismissed. The same motion, if made after the defendant has answered, has a different name, a motion for judgment on the pleadings. So, what the judge considers in ruling on the motion. So I'm going to say failure to state a claim. Actually going to divide this page into 3. This is 12B6. Until the defendant's answer, at which point it's referred to as motion for judgment on the pleadings. After the answer. And then the judge might allow an amendment. What does the judge consider in ruling on the motion for judgment on the pleadings? A ruling on this motion, the court ignores the plaintiff's legal conclusions. It looks only at the plaintiff's allegations of fact on the face of the complaint and not any evidence, and asks if these facts are true, do they state a plausible claim? The answer is no, the plaintiff does not state a plausible claim. There's no sense in letting the case proceed because the law does not recognize a claim on these facts. Remember, the judge uses her experience and common sense to see the facts state a plausible claim. So, obviously, plausible claim is the standard, and it's decided by the court. The motion for summary judgment then is FRCP 56. I think this can be the party move. Wait, the motion for summary judgment is used after the case has been filed and the plaintiff has survived any Rule 12 motions. So we're in the litigation stream, but the trial might not always be needed. Summary judgment weeds out cases in which no trial is necessary. The only reason to have a trial is to resolve a dispute of material fact. And I think that's their standard, is no genuine dispute of material facts and entitlement, then judgment as a matter of law. JMOL. So those are the two requirements for the party that moot motions for summary judgment. If the standard is met, the court is not always required to grant the motion. There may be some discretion to deny the motion measured by an abuse of discretion standard on appeal. All right, we're on page 86. Timing of the motion can be pretrial matters considered, and the court may delay ruling on a motion to allow party to gather evidence. Any party may move for a summary judgment no later than 30 days after close of discovery. The motion can be for partial judgment, for example, as to liability, and the case can go to trial on damages. Partial summary judgment, sometimes called summary adjudication. Okay. Matters considered in a summary judgment motion, the court can look at evidence. The court views that evidence in the light most favorable to the non-moving party. The parties proffer the evidence usually include the affidavits, declarations, deposition testimony, interrogatory answers. But can these things be considered evidence because they are under oath? Court may delay ruling on motion to allow party to gather evidence. If the party opposing summary judgment needs more time to find evidence to oppose the motion, she may file an affidavit or a declaration with the court stating that what that evidence would be. The court may allow more time for the party to obtain evidence. And this would be like admissible evidence. Or leave it at that. Module 12, conferences, trial, judgment, and post-trial motions. Basic idea: if the case is not resolved through pretrial adjudication, it may be adjudicated at trial. Judicial management, Rule 26F conference, unless the court order says otherwise, at least 21 days before a court scheduling order, the parties meet and confer to discuss production of required initial disclosures, claims, defenses, settlement, and preservation of discoverable information. They must present to the court a detailed discovery plan no later than 14 days after the 26F conference, which is already discussed in the discovery section. Contents of a discovery plan. The plan must include views and proposals on timing, issues about discovery of ESI, including how it will be produced and any problem retrieving it, for example, deleted files, etc. Scheduling order. Unless local rule or court orders is otherwise, the court enters a judgment setting cutoffs for joinder, amendment, motions, completion of discovery, etc. There is a roadmap for how the litigation proceeds up to trial. Pretrial conferences. The court may hold pretrial conferences to oversee the case. final pretrial conference determines the issues to be tried and evidence to be proffered at trial. This is recorded in the pretrial conference order, which supersedes the pleadings. This order is a roadmap of issues to be tried, evidence to be presented at trial, witnesses, etc., so that there are no surprises at trial. Jury trial, if we have a jury, it determines the facts and returns the verdict. If we don't have a jury, the judge determines the facts. In a bench trial, the judge also may hear a motion in limine, which is a pretrial motion outside the presence of the jury to determine whether the jury should hear certain evidence. Right to jury trial in federal court. The Seventh Amendment preserves the right to jury in civil actions at law, but not in suits of equity. The Seventh Amendment does not apply in state court, only federal civil cases. And same fact underlies both law and equity claim, but what if a fact, for example, whether a defendant trespassed on the plaintiff's property, underlies both a claim for damages and a claim for an injunction? The court will decide that fact. Jury demand, a party must demand a jury in writing no later than 14 days after service of the last proceeding. Addressing a jury triable issue. If a party fails to do so, she waives the right to a jury. The last pleading addressing the jury issue is usually the answer. Can get obviously extended. So selection and composition of the jury. In the jury selection process, voir dire, each side may ask the court to strike or remove potential jurors. There are no kinds of challenges. There are two kinds of challenges to jurors. There's for cause challenges and BARBRI challenges. For cause is when a potential juror indicates they may not be impartial, and there's no limited number of for cause challenges. BARBRI challenges for which the party states no reason generally are limited to 3 per side. Importantly, BARBRI challenges may be used only in a race and gender neutral manner because jury selection is a state action, even if it is civil action between private parties. Number of jurors in federal court. How many jurors are in a civil jury in federal court? A minimum of 6 and a maximum of 12 unless the parties agree otherwise. Generally, all jurors participate in the verdict unless the jurors excuse for good cause, and the verdict must be unanimous unless the parties agree otherwise. Jury instructions, forms of verdicts, entry of judgment. The jury decides facts but is instructed on the law by the judge. Parties submit proposed jury instructions to the judge. They do this at the close of all evidence or earlier if the court says so. Conferences regarding jury instructions may be held. The judge may hold an off-the-record conference with parties to discuss proposed jury instructions before final argument and instruction on the record. The court informs the parties of what instructions it will give, and 2, what proposed jury instructions it rejected. The parties must be allowed to object on the record and out of the jury's hearing. This is true even if the party objected during an off-the-record conference. If objections are not made before the jury is charged, given instructions, the objection is waived. A court can revisit that jury instruction only for clear error that affect the party's rights. Form of judgments. There's a general verdict and a special verdict. The general verdict just says who wins, and if the plaintiff wins, what the relief is. Special verdict. In a special verdict, the jury answers in writing specific written questions about the facts in dispute, but it does not say who wins or loses. The general verdict with written questions is a jury not only gives a general verdict, but also answer specific questions submitted to it. The questions ensure that the jury focus on the important issues. And an entry of judgment. If the jury returns a general verdict, the clerk of court will enter the judgment. If the jury returns a special verdict for general verdict with written questions, and the answers are consistent with each other, and with the verdict, the judge approves the judgment and the clerk enters it. But if there's an inconsistency between the general verdict and the written questions, or they're consistent, the answers are consistent with one another but inconsistent with the verdict, the court may enter an appropriate judgment consistent with the answers, or it could tell the jury to reconsider or order a new trial. If the answers are inconsistent with each other and one or more is inconsistent with the general verdict, no judgment may be entered. Again, the court may order the jury to reconsider the order or order a new trial. Juror misconduct, non-jury bench trial, motions at and after trial, including the judgment as a matter of law and renewed motion for judgment as a matter of law. It doesn't say this needs to be done within 28 days, but here it does on the next page. Motion for a new trial. Remitter and additor. Offers of judgment. And there's a nice little chart that I'm attempting to print. Procedural devices that may terminate a case is what it's called. My printer is out of paper. It's not, though. That explains why it's not printing. Oops, okay, so I'm going to go back because we're not even to the end of Module 12 yet. So I'm going to read these in a little bit more detail. Juror misconduct. A verdict may be impeached based on external matters. So if the jurors were bribed or base their verdict on investigation of matters outside the court, a new trial can be ordered. Non-jurors may give firsthand evidence of such things, but a verdict will not be set aside if the misconduct was harmless. In a non-jury bench trial, when there is no jury, either the Seventh Amendment does not apply or the parties waive the right to a jury trial. The judge determines the facts at trial. The judge must record her findings of fact orally on the record or in writing, along with her conclusions of law, which are stated separately from her findings of fact. So, I never knew where this really came from. I knew about the requirement, but you got to record findings of fact and conclusions on the record. The judgment also must be entered. The judgment is very short, just telling who wins and relief. So the judgment needs to be recorded too. Motions at and after trial. Motion for judgment as a matter of law. For centuries, a JMOL was called directed verdict. The motion applies in jury trials. If the judge grants JMOL, the case will not go to the jury. The judge grants the motion and enters judgment. The motion is based upon evidence presented at trial. Standard for granting and comparison with summary judgment. The standard for granting the motion is that reasonable people could not disagree. Okay, so reasonable people could not disagree on the result. It's like a summary judgment where there was no disputed material fact, except that it comes up at trial instead of before trial. Like summary judgment, the court views the evidence in light most favorable to the non-moving party, and timing of the JMOLs after one side has been heard at trial and an issue. For example, say the plaintiff presents her evidence in trial and rests. At that point, the defendant may move for JMOL. As the plaintiff has been heard at trial, the plaintiff may not move until after the defendant presents his evidence. Renewed motion for judgment as a matter of law. The RJMOL is the same as the JMOL, but it comes up after trial. And if granted, the court enters judgment for the party that lost the jury verdict. As with the JMOL, just go there. The court views the evidence in light most favorable to the non-moving party. It must be 28 days after entry of the judgment. The absolute prerequisite to bring is that they motion for JMOL at the proper time of trial before admission to the jury. And not only that, the renewed JMOL motion must be based upon the same grounds. And the motion, there's then a motion for a new trial. Assume that the judgment is entered, but some error at trial requires that we should start over and have a new trial. A new trial can be granted on any non-harmless error that makes the judge think there should be a do-over. A party must move for this within the same time as the renewed JMOL. Some reasons a new trial may be granted. This is also 28 days. Entry of judgment. Okay. The judge may have given an erroneous jury instruction. New evidence may have been discovered that wasn't discovered by due diligence or couldn't have been discovered by due diligence before trial. Misconduct was committed by a juror, party, or lawyer. The judgment is against the weight of the evidence. Serious error in judgment and damages are inadequate or excessive. So you have like misconduct, new evidence. I think the great weight of the evidence is the best one. But inadequate or excessive relief. Yeah. New trial is less dramatic remedy than the JMOL, renewed JMOL. Ordering a new trial is less dramatic than ordering an RJMOL. Why? A new trial results in starting over, so the same party may still win, whereas a renewed JMOL results in taking judgment away from one party and giving it to the other. Remitter and additor. To avoid a new trial, the court might suggest remitter. Additor is not constitutionally allowed, but it is allowed in California. Remitter, the court orders the plaintiff a choice to remit part of the damages, reward, or go through a new trial. That's all I'm going to say about this. But it has to shock the conscience, right? For remitter or additor, the standard is it shocks the conscience. Page 96 is that lovely table that I can't print. Offer of judgment. A defendant can submit formal offers to settle the case up to 14 days before trial. Offer of judgment. I almost think this will never happen, but I'll just write down here 14 days ahead of trial. Ahead of trial, it's basically like a settlement offer ahead of trial. But if your trial doesn't, if you win, but you don't win that much, just read the thing. Benefit that the rule is that it contains cost-shifting provisions that apply when the plaintiff rejects an offer to settle and doesn't do as well at the trial as the offer. I think that's when all of the costs shift to the party who shut down the offer. So motion for relief from order or judgment. After a judgment is entered, it is possible to obtain relief from it under certain circumstances. The grounds are clerical error, mistake, excuse, neglect, fraud, misrepresentation, or misconduct, newly discovered evidence, judgment is void. For example, the court had no subject matter jurisdiction. As for the timing, a clerical error can be made at any time, or motion relief from a clerical error may be made at any time. Everything else is reasonable time, not to exceed 1 year, unless the judgment is void because there's a lack of subject matter jurisdiction, in which case there is no maximum period. Appellate review is Module 13, and interlocutory appeals is another part of that. And then the 14th module will be about claim preclusion and re judicata. So let's just get 6-7 more pages to go. Oh, I like that chart too on page 110. So, all right, so let's get through these last 6 pages and hopefully end before 2:30, which was the goal. The basic idea in the appellate review is the federal district court has entered a judgment, order, or judgment, and the losing party wants to seek review by the United States Court of Appeals or for the appropriate circuit. The final judgment rule, the losing party has a right to appeal if the court's order is a final judgment. A final judgment is one that determines the merits of the entire case. And to determine whether an order is a final judgment, ask, after making the ruling, does the trial court have anything left to do on the merits of the case? The answer is yes, it's not a final judgment, but rather an interlocutory order. If the answer is no, the judgment is final. Remand orders with some minor non-testable exceptions are not reviewable on appeal. Notice of appeal. The judgment is final. Where and when the notice of appeal is filed, the notice of appeal must be filed with the district court within 30 days after entry of the judgment that is being appealed. So the appeal is at the district court within 30 days after entry of the judgment. And interlocutory appeals is when you don't have a final judgment. It might be appealable anyhow using one of these doctrines. Interlocutory appeals of injunctions as a right. We talked about this already. Orders granting, modifying, refusing, preliminary and permanent injunctions are reviewable as a right despite the fact that the order may not be final. However, this type of review does not include TROs. Changing nature of TRO. Remember, TRO is good for a maximum of 14 days, renewable for up to another 14 days. If the TRO is renewed beyond 28 days, it ceases to be a TRO, but rather becomes a preliminary injunction that may be appealed. The court cannot avoid review and the procedural requirements of a preliminary injunction by extending a TRO. Interlocutory Appeals Act. This allows a non-final order if the district judge certifies that it involves a controlling issue of law as to which there is a substantial ground for difference of opinion, and the Court of Appeals agrees to hear it. Collateral order doctrine. The appellate court has discretion to hear an appeal on an issue that if that issue is distinct from the merits of the case, involves an important legal question, and is essentially unreviewable if parties await a final judgment. Multiple claims and parties, when more than one claim is presented in a case or when there are multiple parties, the district court may expressly direct entry of a final judgment as to one or more of them if it makes an express finding and there is no just reason for delay. Class action. A court of appeals has discretion to review an order granting or denying certification of a class action. The party seeking review must do so at the Court of Appeals within 14 days of order. An appeal does not stay the proceedings at district court unless the Court of Appeals or district court says so. An extraordinary writ, mandamus, or prohibition. An extraordinary writ of mandamus or prohibition is an original proceeding in the Court of Appeals to compel the district judge to make or vacate a particular order. The writ is not substitutable, is not a substitute for appeal. It is available only if the district court is violating a clear legal duty. So these are kind of your interlocutory appeals. They are of multiple types. Preliminary injunction, collateral order, doctrine. Interesting they didn't say what that really requires. The appellate court has discretion, but I think it needs to be like an in-bank like decision to hear. Court discretion, I'll say. But it's an important legal question. Essentially unreviewable if parties await a final judgment. Then there's multiple claims and parties. And class actions. And then you've got the extraordinary writs of mandamus and prohibition. And what about habeas? That's probably on a final judgment, or else it would probably be said here. Standards of review and appeal. I'm glad this section is short. What is the standard of review? Looks to be that there's 4. Review of questions of law is a de novo standard. No deference is given to the district judge, district court justice. Then you have questions of fact at a bench trial. Besides BARBRI, I feel like I could have never looked this information up myself. In a non-jury trial, when the district judge determines questions of fact, the Court of Appeals will affirm unless the findings are clearly erroneous. Right, so there's a lot of different deference given. There needs to be like a clear error on the transcript for questions of fact at a bench trial. But what about questions of fact at a jury trial? I feel like this goes to the court, district court, but they're given great deference in a jury trial. When a jury decides a question of fact, the Court of Appeals will affirm unless reasonable people could not have made that finding. So great deference. The standard is reasonable people could not have made that finding. And lastly, review of discretionary matters. This is an abuse of discretion standard. And then there's harmless error. And it doesn't really say specifically what that goes to. or what type of question, whether it be fact, issue, whatever. So the last section is claim and issue preclusion. The basic idea is whenever there has been an earlier case, watch for these issues which concern the preclusive effects of a prior judgment on the merits. The question is whether the judgment already entered precludes litigation on any matters in another case. Case 1 and 2 are different judicial systems, for example, state and federal courts or courts in different U.S. states. The court in State 1 applies the preclusion law of the judicial system that decided Case 1. And the first kind of the two that we're going to discuss is claim preclusion, also known as res judicata. A claimant may sue only once to vindicate a claim, so you only get one case in which to seek recovery for all rights to relief for that claim. Requirements for claim preclusion. I wonder if I could just write these down. It's like a final judgment on the merits between the same parties or their privities in the same position on the same claim, right? So let's read it. For a claim to be precluded or barred, three things have to be true. Same claimant suing the same defendant were brought and valid. So I forgot valid. Final judgment on the merits. Case 1 must have ended in a final judgment on the merits unless the court said the judgment was without prejudice when entered. Any judgment is on the merits unless it was based on a lack of jurisdiction, both personal and subject matter, improper venue, or failure to join an indispensable party. This is true even if there was no adjudication in Case 1. Case 1 and Case 2 must have the same claim, must be the same claim. The majority view, including federal law, is that a claim has any right to relief arising from a transaction occurrence. So this is the majority. Right to relief arising from the same transaction or occurrence. I've heard that too. There's another primary rights doctrine under this view in the minority. And I think it's also California that would see separate claims for property damage and personal injuries that arise in the same event. So like property rights and personal injury rights, they're separate rights, but under the same claim. The theory is that the property damage and personal injury invade different rights to be free from personal injury and one to be free from property damage. Issue preclusion, collateral estoppel. Issue preclusion is narrower than claim preclusion. Here, an issue was litigated in Case 1. The same issue is then presented in Case 2. But if issue preclusion applies, the issue cannot be relitigated in Case 2. It is deemed established in Case 1, thereby streamlining the scope of litigation in Case 2. There are 5 requirements for issue preclusion. So many of them are the same. That there's a valid final judgment on the merits. What's different? The first difference is that the issue was essential and it was actually litigated. Necessarily decided is what they call it. There's another way to say it's essential. And so those are 3 requirements. The issue must have actually been litigated. The issue must have been essential to the judgment, meaning that finding on the issue is the basis of the judgment. And against whom is the preclusion used? Due process factor. Issue preclusion can be used only against somebody who was a party or in privity with a party, meaning that the party to Case 1 represents someone who was not a party to Case 1. For example, a class action binds all members of the class, even though not all class members are parties to the action. They are represented by a class rep. The requirement that the person against whom issue preclusion is being asserted be a party or in privity is a principle of due process. Every person generally is entitled to a day in court before her property is taken or rights are affected. And by whom is preclusion used? Mutuality rules. So I'm just going to call this a due process factor now. And I'm going to call mutuality rules as the fifth factor. But there's a lot of expansion in this area recently. So every court agrees that issue preclusion can be used by someone who was a party to case one or privy with that party. The big question is whether it can be used by someone who was not a party to case one or in privy with that party. When someone who was not a party to case one tries to use issue preclusion in case two, it is called non-mutual issue preclusion. And non-mutual defensive issue preclusion is when the person using preclusion was not a party to case one and is a defendant in case two. The inverse is non-mutual offensive preclusion, where the person using the preclusion was not a party to case one and is a plaintiff. Non-party defendant is defensive. Offensive would be non-party plaintiff. And so in order to determine, unless the state that you're in is specific, has specific rules, you consider certain fairness factors to determine whether non-mutual offensive issue preclusion is fair. So actually it's only when you have a plaintiff trying to use issue preclusion for a judgment against a defendant. The following four considerations have to be reached. The party to be bound has had a full and fair opportunity to litigate. Full and fair opportunity to litigate. Two, the party to be bound has a strong incentive to litigate. Like they brought their strongest argument, basically. And the party asserting issue preclusion could have easily joined into case one. They might not let you use. So plaintiff party could have joined, and then it would be like kind of unfair for them to come in after the fact. Has already been argued. And lastly, there have been no inconsistent findings on the issue. What does that mean? So if there have been multiple cases, and sometimes in case one, I guess if it had been like appealed, I think is what they're trying to say. And so that's going to be it. That's going to be the end of it. That's going to be the end of this recording.